There you go. Thanks. Achieved that objective first on. So welcome to this April 2022 breakfast briefing on managing apprentices. The focus today is really going to be on, I suppose, how to set up and manage an apprentice program, number one, but a big part will be on the differences that exist between the standard employer-employee relationship that exists between your employer and you, but the different one that applies to apprentices, because it's fundamentally different and much more challenging, I would say. Although a lot of today might sound as if it's negative in terms of how to manage that relationship, I need to be absolutely clear. I'm a massive believer in apprenticeships. In my last real job, I ran an apprentice program which had been going since, I think, 1974, where we'd taken 3-4 apprentices each year. And although the organisation was in what I could, I suppose, describe as financial distress, literally the last thing that we looked at was our apprentice program. We just determined that, you know, creating and growing your own staff from an apprentice program was worth more than the money. And I suppose lots of people on this call will be in organisations where, or will be individuals who've been through an apprentice program themselves. So managing apprentices, an apprentice will cost you probably £50,000 in actual costs, and developing a modern apprentice over a 4-year program could cost you £100,000 in cash and non-cash costs. It's an investment. So I don't like to talk about apprentices as being a cost. I like to talk about it as being an investment. So on that basis, I've just got a few people just to admit. I'll be there in a minute. I'd like it to set against that. Massive believer in apprentice programs. I think it's morally and ethically a really good thing for us to do. And I think it allows us, I think, a really good opportunity to develop people into our culture over the period of an apprentice program. So we shall get cracking if I can get my IT to work. It's early morning. I never put my video on. No one wants to see me this stage in the morning. So what we're going to focus on really is modern apprenticeships. Probably, or as you may know, there's a number of other apprentice style programs that exist. As an example, one which is relatively recent has been the creation of foundation apprenticeships. Foundation apprenticeships effectively subsumes the latter part of the school career into an apprentice program, such that by the end of the foundation apprentice program, someone is a good way through their modern apprenticeship program. It's benefits for the employer because it's cheaper, because the costs associated with that are much less, and it's really good for the individual because if you get into 4th year at school and you're not academic, then it's an opportunity to try something fundamentally different. But this morning we're going to focus really on modern apprenticeships. So a modern apprenticeship is a structured program of learning. Generally it will contain academic, or always it will contain academic elements and on-the-job attainment, functional attainment. If you go on, and one website which I'd recommend to everyone is apprentices.scot or apprenticeships.scot. And if anyone's struggling for that, I'll send it out after this meeting. And it basically sets out all of the kind of structured pathways to achieving a modern apprenticeship. There are, I think, about 620 different modern apprenticeships. Obviously, the one that most of us, or the ones that most of us will be involved in, will be things like mechanical and electrical fitters, welders, fabricators, whatever that is, obviously being in an engineering environment. Normally, those engineering programs will constitute 3 or 4 different academic elements. SVQs at potentially different levels depending on the choice of the employer and the apprentice, but also an NC, at least an NC, sometimes greater than that. Sometimes people want to go for HNCs or ONCs, and we can do that as well as part of that program, but the minimum normal attainment is an NC. And with that, we'll go an SVQ at level 3. And the SVQ is basically where we formulate the workplace learning. So where an apprentice will observe a task, then do the task, and will record the details of that in what's referred to as the logbook, which effectively is just a detail of the learning the apprentice has done over the period of their apprenticeship. Normally what happens is, in terms of awarding an apprenticeship or completing an apprenticeship, the SVQ needs to be verified and assessed with the whole of the programme. So that verification will contain the verification of the on-the-job learning and the confirmation of the academic learning. It's likely that certainly for most of us, in terms of the size of your organisation, you're unlikely to have internal verifiers and assessors. So in most cases, all of us will need access to a learning provider, even if it's just for verification and assessment and for that first year of training. Normally, the first year of a modern apprenticeship is spent wholly at a college or a learning provider. A modern apprenticeship programme in the engineering sphere tends to last between 36 and 42 months. That's normally the contractual length of an apprentice contract, and it's normally the period in which funding is available, which we'll talk about in a wee second. I suppose the big focus of today is going to be the unique contractual situation that apprentices enjoy. As an employer, it's more difficult, but when we consider this from a moral and ethical perspective, the potential for apprenticeships and the funding of apprenticeships and their ability to pay apprentices less than minimum wage, national minimum wage for part of their programme, means that apprenticeships are effectively ripe for exploitation. If you can employ someone, you know, the first year of an apprentice programme, the annual salary is about 8,000 quid. So there's a massive responsibility on the employer to manage a proper apprenticeship. You know, I think in days gone by, people would bring on apprentices, have them in for a year, and then get rid of them and just get effectively a labourer for a year. So with the funding, goes a kind of really strong responsibility on the part of the employer to manage a proper apprenticeship. But with that comes an additional responsibility in terms of that contractual relationship, which we'll talk about just in a second. So normally, I won't read out slides to you. I'm going to go ahead on the basis, even though it is early morning, people can pick through what is on the slides. But normally it's 1 year at college and 2 to 3 years spent in the workplace, 2.5 years normally spent in the workplace. And that's putting together the SVQ, learning the tasks that are associated with the role, recording all of that in a format that is acceptable to a verifier and an assessor. So that will be, you know, a range of on-the-job tasks under observation by someone who is competent to observe and assign someone who's been competent in doing it. There is funding available. Funding generally is a kind of variable feast in terms of the funding that's available through, fundamentally through Scottish Enterprise, but it flows through Skills Development Scotland. Funding is basically targeted at areas of need. So in apprenticeships where there is not a significant need in the general workplace, funding is lower. Where we have shortages and labour shortages, then funding tends to be a bit higher. Funding in any regard is not sufficient for you to pay an apprentice for 3 or 3.5 years. Normally, I think the maximum at the moment is about £9,000, and that's over the period of the apprenticeship. And that money is released in stages. So if you apply for funding and get that funding, you need to have a quarterly review with Skills Development Scotland for that funding to be reviewed, if that funding to be issued to you. It's a relatively onerous task, and it's why in most cases, and certainly when I managed an apprentice programme, we did it on our own initially, and then paid separately for tuition. But lots of learning providers, especially lots of further education colleges, will apply for the funding on your behalf, will do the quarterly reviews on your behalf, and will give you your tuition, your verification, and your assessment for free as part of that funding. So that's a very normal relationship. The college will also get funding from the government in order to deliver the training to the apprentice. But I think that's a pretty sensible approach. The 2 or 9 or 4 or 5 grand that you might get for, let's say, a mechanical fitter is not going to break the bank for you. But if it pays for your tuition, it pays for your verification, it pays for your assessment, then that's a pretty sensible approach. So in terms of just day-to-day managing of apprenticeships, we should manage apprentices fundamentally like other employees, understanding that they are very young. They could be 16 when they enter the workplace. And it's probably an education for us to remember what it's like to be 16, 17 or 18 and coming to work on a daily basis. But on a basic terms, we should manage apprentices as we would do any other staff. So that's in relation to things like conduct, performance and attendance. They don't necessarily get a buy in terms of, well, they're allowed to be late or they're allowed to behave poorly. Where the fundamental difference remains, and it's what we'll talk about for the remaining, is that The modern apprenticeship contract is fundamentally different to your standard employment contract. So you might have for your staff a standard statement of terms and conditions or a full employment contract, detailed top to bottom, and that spells out the relationship between the individual and the employer. And if there's a fundamental breach of that contract, either through conduct or any other means, then it's generally fair for an employee to dismiss an employee to dismiss an employee. However, if I am employed as an HR advisor in Scottish Engineering, the principal reason why we recruit apprentices and the legal status of their contract is that they're there to learn. They're not there to do a job, to be a mechanical fitter or an office administrator. The principal focus of the employment contract for an apprentice is to be trained. And that means that that's the employer's responsibility, is to provide training. And it means that to breach that contract, then it's that element of training that needs to be breached. Effectively, the apprentice would need to be untrainable. So employee contracts, it is difficult to end. We will talk about that later. You will probably know, if you've had any experience with managing people, there are a number of fair reasons for dismissal, things like redundancy, conduct, capability, etc., etc. It is much more complex and much more difficult to terminate an apprentice contract, and certainly before the end of its time. I suppose just as a general rule, we have template apprentice contracts if anyone doesn't have them. But the key thing in an apprentice contract is it should be for a fixed duration. We have some employers who take our services who have an open-ended apprentice contract. An apprentice contract should be fixed term, fixed duration for the period of the funding, for the period of the modern apprenticeship, which is 36 to 42 months, sometimes maybe up to 4 years to include any kind of extensions. So again, if you want some help on apprentice contracts, let us know. Apprentices also enjoy the same benefits as all of us, in that once they've reached 2 years service as an apprentice, then they have employment rights. So they have rights to take us to tribunal, and they should be treated exactly the same way as normal employees. So even after 2 years, if you dismiss an employee, an apprentice, you need to dismiss them fairly as you do any other employee. And what we'll also know, and something probably that's changed in the last 10 years, is ending a fixed term contract still counts as a dismissal. So we're probably in the good old days, when I had a real job, you would take someone in the fixed term, you'd have them in for a couple of years, and then you'd shake your hand and let them go, and that would be the end of it. But people can now acquire rights after 12 weeks of employment, regardless of their status, but certainly on a fixed term. And any failure to extend a contract counts as a dismissal. So potentially it's, in most cases, a fair dismissal because someone's coming back to work or whatever reason. But in general terms, we need to consider that as well. I want to talk today about graduate apprentice contracts, because a graduate apprentice contract is fundamentally different and is pretty much just like an employment contract. So the fundamental reason for a graduate contract, a graduate apprentice, is normally to achieve tasks. It's normally to learn tasks through the organisation. The graduate apprentice contracts don't have the same protection as a standard Scottish apprentice contract. And I say Scottish specifically because the Scottish apprentice contract provides more protection for the employee than the rest of the UK. So as said, normal reasons for dismissal are correct. You know, if we manage them correctly, we can dismiss our employees. But if the principal role of the apprentice is training, and it is, the contract that we have with the individual is to provide training, and the mutual contract that we have is for the individual to learn. And that effectively is the essence of an apprentice contract. So in order for us to dismiss an apprentice, we must demonstrate that we can't achieve the principal aim, which is to train them and for the apprentice to learn. So it's generally either matters of competence, or it's something so fundamental, the apprentice has done something so fundamental that it has breached the contract of employment that exists. It's breached the implicit terms of an employment contract that exists. So we need to demonstrate, as an employer, if we choose to dismiss an apprentice before the end of their time, we need to demonstrate that they are wholly untrainable. There's a lot of case law on apprentice contracts, and that is the terminology. Helpfully, as anyone who knows anything about HR employment law or reads case studies about these things, there's generally not a black and white. there's generally some kind of grey area. So wholly untrainable does not have a definition in terms of this is what it means. But through a number of different cases which have gone through tribunal and employee appeal tribunal, in terms of the reasons that are given, there are a couple of reasons when we can determine that an employee, an apprentice, is wholly untrainable. So that would be, as an example, the training provider, which is you as an employer, determines that the apprentice can't complete the academic element. So if your college tells you that, Joe Bloggs will not complete this, doesn't have the competence or ability to complete the NC or the performance engineering operations or whatever other element of the programme exists, or they've exhausted their opportunity to resit, or the college just walks away and say, I can no longer support this apprentice, that's potentially a fair reason for dismissal. If, on the other hand, when we're doing workplace assessments with the competent staff that we have, if we determine that the apprentice can't complete the workplace assessments either in time or to an appropriate standard, that might be justifiable reason for dismissing an apprentice through the period of their apprenticeship. Also, if they commit an act that's so serious that the employer is entitled to consider the contract is breached. Now, what I would say is, in general terms, the conduct that we would not accept from our normal employees, generally we probably would accept from apprentices, and that's difficult for us to take on. So if you've got breaches of conduct or breaches of absence or late coming or whatever that is, we might get to a stage for apprentice where we're issuing final written warnings but not taking the ultimate step of dismissal, because it has not yet passed the test to say that the individual is wholly untrainable. Like everything in HR, and it's why we exist to advise sensible, intelligent, competent people, is that it's a judgment call. It will be a judgment call. And effectively, like all of these things in the dismissal, can I convince a third party who is reviewing this case that I have built up that my actions were justifiable and proportionate? So, if the apprentice is late 4 times in a year, no. If the apprentice is late every single day for 4 weeks, potentially. But it's that kind of thing. Also, by redundancy, apprentices should not be considered as part of a normal redundancy programme. So if you are contracting the workforce, apprentices should literally be the last people who are considered for redundancy. And that's because if the principal reason they are there is to be trained, then the only time when that might impact on an apprentice is, let's say, if we no longer did electrical fitting work, if we no longer did electrical work and our apprentice was an electrical apprentice and couldn't translate into something else, if we no longer had the capacity to support the apprenticeship because we didn't do the work that would allow them to achieve it, that's potentially fair. But the best time, and if we need to dismiss an apprentice, is at the end of their apprenticeship. And we'll talk about how we build up that case if we determine that someone is pretty poor. If anyone on this webinar has contacted us at any stage for apprentice advice in terms of their conduct or how to dismiss, our first answer and our second answer and our third answer is always drag them across the line, get them finished. And whatever steps you need to take to get them to finish, get them finished. You're not training them to join your workforce, you're just training them to complete their apprenticeship. And morally and ethically, that's a bit of a challenge, I suppose. But it means that the apprentice can get their papers and go somewhere else or do something else. But it is by far and away the easiest method by which we can move an apprentice on who we determine to be not for us. So from a capability perspective, everything is a much higher threshold. So these are some kind of basics of fair reasons for dismissal, normal fair reasons for dismissal. But even from a capability perspective, if we determine that someone's not capable, we need to demonstrate that we have offered every support to that apprentice that is reasonable. Now, that doesn't mean doing their work for them. It doesn't mean getting someone else to do their work. But what it means is we take them off of, let's say, once they're into maybe 3rd or 4th year, they might be doing effectively full time on a shop floor somewhere. It might mean taking them off of the shop floor and only letting them go there when they need to learn a task, extending the time up to the limits of their contract and potentially beyond if there have been issues during the apprenticeship. And you might also need to consider that even if the person's not capable of completing an apprenticeship as, let's say, a mechanical fitter, is there any alternative employment that we can offer them before we take the ultimate step of dismissal? Is dismissal the only option for us? From an attendance perspective, routine and regular late coming, that is so serious that it has an impact on their ability to learn the job, to interact with others, to attend college, certainly. All of these things, if it is so serious, then that will become an issue. As an example, if someone doesn't turn up for college and the college take the huff and say, I'm no longer supporting this person, then that may well be justifiable reasons for a dismissal, where we can say this individual is untrainable. They will not go to college. They will not do the work when they get there. They are untrainable. I cannot achieve the objectives that we've set out in our contract. And from a conduct perspective, it would need to be something so serious, are repeatedly neglectful, so significant health and safety concerns, going AWOL for significant periods of time. You know, any aggression or violence is fair game, I think. But the things that you may tolerate or you may not tolerate from the rest of your staff, you may need to tolerate slightly more from an apprentice perspective. It doesn't mean to say you can't issue warnings, and I would always suggest that if an apprentice is due a warning from a conduct, attendance or absence perspective, that we should issue it. And also from a capability perspective. So we should do the dance with apprentices in the same way that we do for all of our employees. We should have performance improvement plans. We should have attendance warnings for absence. We should have conduct warnings. We'd issue first, second, finals, whatever that is. But before we take the step between final warning and dismissal, we really need to have asked ourselves some serious questions. And I would say, taken some advice on the case that you've brought up. Because remember, you're not trying to convince yourself that it's fair, and you're not even trying to convince the apprentice that it's fair. You're trying to convince a third party, and that third party could be an employment tribunal. And employment tribunals will naturally put the focus and the pressure on us to demonstrate that this was not just minor breaches of conduct. This meant that we could not achieve or fulfill the contractual relationship that we have with this individual. So even apprentices, there's some significant case law. We've talked about redundancy before, but in order to make an apprentice redundant, the business would need to be in significant financial distress. I don't mean we need to cut some people out. I don't mean we've got a few too many heads, we don't have a lot of work in. It would need to be sustained financial distress, such as, you know, threats of liquidation or that kind of financial distress. Obviously, if the business closes or a part of the business closes where those apprentices work, then there's potentially justification in making an apprentice redundant on the basis that the structure, the format, the support network that exists in order to help them achieve it doesn't exist anymore. And that would make, you know, a fundamental change in business. There's a really interesting case. It's Marley, the building supply people, and it's always kind of held up as an interesting piece of case law on apprentice is in relation to redundancy. And they'd made an employee redundant because the thing that they were training to do was no longer being manufactured or used, and they made them redundant without making any consideration for what else they could do. Because even if you've got mechanical and electrical, let's say engineering or fitters that you're going through an apprentice program, a large part of that program is the same. So, you know, 2 years into those programs, both apprentices in either discipline will have done much of the same work. So we need to consider whether, is it the discipline that's wrong? So if someone's not competent to do electrical work, are they competent to do mechanical work? Are they competent to do any other apprentice program that we have that they could translate into? So from a redundancy perspective, they are last cab off the rank in relation to who we consider for redundancy. So what I would say is, as anyone knows who's taken advice from us, and as I have said, the primary objective is to get a poorly performing or poorly behaving apprentice through to the end of their time. And that means that it gives us an opportunity at that stage fairly to say, you are not for us. You know, the manner in which and the conduct that you have demonstrated during your apprenticeship, your absence record, everything else demonstrates that you are not someone who we want to employ. And the reasons for that are these. And if what we can demonstrate is, you know, that we've issued warnings for apprentices, for attendance or for conduct or for absence or anything else from capability perspective, or we've had to offer support that is fundamental to the point where we just pretty much don't trust the apprentice to become, you know, a bona fide tradesperson in our organisation, then we can potentially end that fairly. Without wishing to get into the detail of what the fair reason for dismissal is, and it's a term you may hear bandied about even if you don't work in HR, Effectively, it would normally be some other substantial reason dismissal. It's not generally redundancy, because the role that they're in has ended in any event. It may be redundancy if we don't have opportunities, but in most cases, it will be what's termed as some other substantial reason. So there are fair reasons for dismissal, so misconduct, capability, etc., etc., a number of them redundancy. Another one is called some other substantial reason, and it effectively is a bit of a catch-all. It catches anything which is a breakdown in trust or confidence between the employer and the employee, and is a fair reason for dismissal as long as we follow a fair process. We can't just get to 4 years where there's zero record of any intervention on behalf of the employer and then say, actually, you're no for us. It's some other substantial reason dismissal. Thanks very much. It still needs to be justified as a fair dismissal. And to demonstrate a fair dismissal, we need to undertake a fair process. And that means creating over the 4 years or 3 or 4 years of an apprentice programme, the justification for either keeping them on at the end of their time or the justification for potentially dismissing them. And like any dismissal, we should consider actions short of dismissal before we determine that a dismissal is fair. So action short might be, I don't want you here as a welder, but you can go and work in the stores. Or, we've got some other means in which we could employ someone such that dismissal is effectively the last resort that the employer has. So in terms of what we should do during an apprentice programme, we've obviously got someone who's taken control of the learning part of it. But for us, we should maintain those records of progress, identify those areas of concern, offer support, detail the support that we've been given. We should engage with our training provider routinely. Generally, depending on how it operates, they will come into the workplace, every now and again to assess the tasks that people are doing. We should meet with them to determine how things are going. We should take notes of those meetings. We should discuss those with the apprentices. We should identify areas of concern and take action. Even if we don't have a performance appraisal system or performance management system generally in our workplace, we should do something with our apprentices. We should record their progress, and we should make sure that we talk to them routinely about how they're doing, what they need to do, where the support being offered is. Like as I've said before, where we do have conduct issues, where there's late coming or absence, we should investigate as we normally would. We should warn as we normally would. But in most cases, unless it's something that's fundamental to that breaches the terms of their contract, we should probably not dismiss, or we may not dismiss. Before we dismiss, take advice either from ourselves or wherever you take your HR and employment law advice. Take advice, and that's the test that we will, subject your case to. Is this the last resort? Have they fundamentally breached the terms of their contract? So a portfolio of evidence and some form of investigation. So you may, if you're at the end of their time, you may not do an investigation in the way that you would normally do an investigation, but you should have a report that goes in front of someone who will make the determination whether to dismiss or not to dismiss. So that should be a timeline, a narrative report, input from the training provider. That should all form part of that portfolio that goes in front of someone who will determine whether we keep the apprentice on or whether we don't. And like every other fair dismissal process, an apprentice who is dismissed and some other substantial reason should have the right of appeal, or for any other reason, whether it's conduct or whether it's redundancy, should have the right of appeal. So my advice on anything is that if you can drag them through, then do so. It may be that makes your case to say that I don't want this person in the workplace after the end of their time. But from a kind of ease of dealing with it situation, it is much easier to deal with an apprentice at the end of their time who's got a poor record than it is to dismiss through their time. If during the course of their apprentice programme, you can reach some kind of agreement that, listen, this is no working, it's no working for you, it's no working for me, you don't want to do it. If the apprentice won't resign to say, yeah, I agree with you, I'll just chuck it, then it's something you may want to talk about, a settlement agreement. No massively expensive settlement agreement, but settlement agreement is a legal agreement where the employee signs away their rights to take further action against us. And it's something to consider. Or can we give them something else to do? Can we get them something else? I suppose one thing I want to scare you with is if we dismiss an apprentice unfairly, then there's two angles to how an apprentice can win an employee tribunal if you haven't done it fairly. Number one, if we haven't dismissed them fairly, then they can claim unfair dismissal, provided they have 2 years service. So like any of us, if someone comes into you today and say, get out, I don't like the look of you, then we can claim unfair dismissal. And if we haven't done it fairly, then we run the risk of an unfair dismissal loss. Further, an apprentice can claim a breach of contract from day one. So we all have the right to claim breach of contract where our contract has been breached. But an apprentice can claim breach of contract because if we treat them as just another employee, if we don't take cognizance of the fact that they have a separate and individual set of terms and conditions with us, then the potential is, if we unfairly dismiss them, the potential is we will further have breached their contract. The fear in that is that an apprentice who we unfairly dismiss can claim not just for, so if any of us are dismissed, we can claim for unfair dismissal. And unfair dismissal awards, if we win, is normally, the kind of compensatory element is normally based on an estimation of your losses. So if I'm unfairly dismissed on Friday and I start a new job on Monday, then if I win, I will win a basic award, but the compensatory award might be limited because, well, you've not really lost anything. You start a new job on Monday, you might win a very small amount at tribunal. However, from an apprentice perspective, if we dismiss an apprentice after 2 years service of a 4 years apprenticeship, an apprentice can claim not just for the losses in wages if they have lost wages, but from the future impact on their earnings. So if they've not been able to qualify as a welder, where they might have earned 27, 28 grand, and now that person has fundamentally different career aspirations or different career prospects, then they can claim for that loss. They can claim for denial of the opportunity to earn in the trade in which they were training. So that can be fairly fundamental. I say the Kinnear case v Marlight was a breach of contract from day one. Breach of contract awards is limited to £25,000, but they can claim for their losses, their loss of career prospects, and from that breach of contract perspective, whether the contract has been breached. So for all of that, that is why when people talk to us about apprentices and how to deal with apprentices, there is occasion when they get frustrated that we are so risk averse in relation to how we help people deal with apprentices, but it's fairly fundamental and it's very expensive, and morally and ethically it's pretty much a challenge as well. You know, if employee tribunals occasionally reach the papers, and this is one which has potentially reached the papers in a fairly embarrassing way. So ever the professional, I have gone 3 minutes over. That is me finished. Does anyone have any questions for me? I've got the sound of silence.
Morning, Dermot. This is Michelle. It's just, no, that was really good and really informative to think about it from the legal aspect. If you're taking on MEs out with your own organisation, you know, so not growing your talent within, but obviously recruiting in as such. And it's interesting that, so the takeaway for me is to differentiate that they're coming in to train. You're not training them to fill a job.
Yeah.
Honestly, that was my thinking, was like, if we bring external in to grow, you know, then the idea is obviously they would grow into that role. But I've got to then work with my leadership team for them to understand that actually, no, what we're doing is we're bringing in younger talent or, you know, less experience to get them the experience and give them the training. And that's really it.
Exactly right, Michelle. And I think that there's two elements. I mean, obviously, I would not, as an employer, want to take on apprentices if I thought in 3 or 4 years' time I don't have a role for them. You know, from two perspectives, I don't want to set expectations for an apprentice that we've got a role that they might not have. But on the flip side, it's an investment that we don't need to make. So I would always, you know, apprentices are part of your recruitment strategy with people who are coming from outside. But yeah, I think that's a key point, Michelle, is that whilst this is an investment and this is something that we're doing for the greater good and also to satisfy our own recruitment needs and to get staff fully trained, understanding our culture, we know how they work, they know how we work. But from that perspective, I think there is an element where we need to consider an apprenticeship as, at least in part, altruistic. at least in part, we may not get anything from this. We may not have the opportunity to employ them. But from a principal perspective, we are making an investment, and it's investment that we hope will pay off. But ultimately, it may not. And that can be a real challenge. And I know there'll be people on this call who I've spoken to about apprentices, where it's been dragged them through to the end and then just let them go and just write it off as a, well, it's what we do, it's what happens. So there's always an element of apprenticeship. We could sit as a fair-sized employer and just recruit people from outside, fully trained people. But there is an element we want to grow our own. There is an element that's altruistic, this is the right thing for us to do. And if we work in an engineering environment, probably all of our senior management team and most of our managers will have been through an apprentice program, either with us or somewhere else. So I always like to think, it never really annoyed me when we had apprentices who would do their time and then do maybe a year or 2 years and go somewhere else. Because, well, I've trained someone, they've got good career prospects, but at the end of the day, I'm going to employ someone from somewhere else who's done an apprenticeship somewhere else. So operating that principle, it was rarely something that annoyed me. But thanks for that, Michelle, really good point.
Thank you.
Any other questions, comments? Well, if not, I will say thanks very much for this morning. And as I normally say at the end of breakfast briefings, away and get on with your work, and we will see you next month for our next breakfast briefing if we don't see you before. But thanks very much for being here this morning. Take care.
Thank you. Thanks.
Thank you,
Bye-bye.
Dermot. Have a good day.
You too. Thanks.
Bye.